Սիրելի բարեկամներ, ինչպես դες նախապես հայտնել էինք, Սփյուռքի ձայնը այսուհետ ունենալու է հաղորդաշար իրավաբանական թեմաներով։ Եվ այսօր սիրով իմ եթերը ուզում եմ տրամադրել իրավաբան Yelena Nersesyanին, որը եւ վարելու է այդ հաղորդաշարը։
Hello and welcome to Legal Affairs. Today our guest is Talar Iskanian-Hashasian. Talar has been practicing immigration law for over 18 years in various settings, in private law firms and non-for-profit organizations. Talar assists her clients in Armenian, French, English and Turkish languages. Hi Talar, and thank you so much for being here.
Thanks for having me. It's a pleasure to be here.
Before we get to our discussion, please say a few words about your practice.
My practice focuses exclusively on U.S. immigration and nationality law. I represent corporate as well as individual clients in a variety of immigration matters, including employment-based petitions, family-based petitions, naturalization applications, and related matters. I also, mostly on a pro bono basis, handle cases for victims of domestic violence and victims of other crimes who may be eligible for immigration benefits.
As we all know, the most talked about topic in every immigrant community is the deferred action for childhood arrivals. Can you please tell us a little bit more about this program?
Sure. On June 15, 2012, the Obama administration announced that certain people who came to the United States as children and meet certain key guidelines may request deferred action up to 2 years. And the United States Citizenship and Immigration Services began accepting applications on August 15, 2012. What is deferred action? Deferred action is a discretionary determination to defer the removal of a certain individual if they meet the guidelines. Individuals who are in removal proceedings, individuals who have been removed previously, or individuals who have never been in removal proceedings are eligible to apply if they meet the guidelines. Also, someone who has been granted deferred action is eligible to apply for work authorization, provided that he or she demonstrates that they have a need for work authorization.
Okay, and who is eligible to apply for deferred action under this program?
You're eligible to apply for deferred action if you meet the following 8 guidelines. You were in the United States as of June 15, you were physically present as of June 15, 2012, and you're present at the time of making your application. You're under the age of 31 as of June 15, 2012. You came to the United States before reaching your 16th birthday. You are at least 15 years of age unless you're in removal proceedings. You have been physically present in the U.S. for at least, you have continuously resided in the U.S. for at least 5 years as of June 15, 2012, which means that you must have come at least on June 15, 2007. That you're currently in school, you have graduated from high school, or you have obtained a certificate of completion or a GED, or you're an honorably discharged veteran of the U.S. Coast Guard or the U.S. Armed Forces. You have not been convicted of a felony, significant misdemeanor, or 3 or other misdemeanors, and you do not otherwise pose a threat to the national security of the United States. One of the other requirements is that you entered without inspection or you were not in any lawful status as of June 15, 2012. Individuals who can demonstrate through verifiable documentation that they meet these guidelines are eligible to apply for consideration for deferred action, and all applications are made to the United States Citizenship and Immigration Services.
One of the questions that we received from our viewers is the following. Are the children of parents who are legally in the United States on a work or business visa eligible to apply for this program?
No, unfortunately they're not. One of the requirements for eligibility is that you were not in lawful status as of June 15, 2012. So children who are dependent on their parents' business visas, non-immigrant work visas, are not eligible to apply for this program.
Another major concern that I hear from people is about the risks involved in applying for deferred action. Can you please tell me if there are any risks, and if so, then what are they?
Absolutely. If you're unlawfully present in the U.S. and your request for deferred action is not granted, you may be placed in removal proceedings. Also, as I said earlier, this program doesn't give lawful status to people. It just defers removal for a period of 2 years. This is a discretionary relief, which is temporary, and it may be revoked at any time.
Something that we hear on TV quite often and also read in the papers nowadays is the question whether the result of upcoming presidential elections will affect this program.
We do know that President Obama has put in place the deferred action for childhood arrivals when Congress failed to pass the DREAM Act. And also Governor Romney's campaign has said in October that he would honor the decisions, the cases that were granted under the Obama administration, but that he would not grant any new cases when he takes office.
One of the questions that we received from our viewer is whether the person who lives in the United States and is out of status has an opportunity to apply for a green card.
It is a very case-specific question, so I would give a general answer. It may not cover every specific case. A general rule in immigration law is that someone who is unlawfully present in the U.S. cannot change their status to lawful without having to leave the United States. But it's not always an option to leave the United States because of something called the 3 and 10-year bars. The 3 and 10-year bars is a concept that's been introduced in 1996, and it provides that if a person has been unlawfully present in the U.S. for more than a year and they leave the United States, they are barred from re-entering the United States for 10 years. If a person has been unlawfully present in the U.S. for more than 6 months but less than a year and they leave the United States, they are barred from re-entering for 3 years. This is a general rule. There are some exceptions to this general rule. The first exception is for foreign nationals who are sponsored by immediate relatives. And immediate relatives for U.S. immigration purposes are spouses of United States citizens, minor children under 21 of United States citizens, parents of adult children, and widows and widowers of United States citizens. So the second exception is for foreign nationals who qualify under 245I. 245I is designed to help people who are unlawfully present in the U.S. They have either entered without inspection or their lawful status has expired. So basically what 245I does is it gives these people the opportunity to file for permanent residence, to adjust their status if they meet certain criteria. And what it is that you must have had an application, an employment-based or family-based application, which was filed before January 14, 1998, or you must have had an employment or family-based petition which was filed after January 14, 1998, but before April 30, 2001, and you must have been physically present in the U.S. on December 21, 2000. The third exception is for foreign nationals who qualify under 245K. 245K is similar to 245I, which I just described. The difference is that it only applies to people who are beneficiaries of employment-based petitions, and it only covers a period of up to 180 days. The fourth exception is for asylum applicants. This is a limited exception. Asylum applicants usually are required to file their asylum application within 1 year of entry to the United States, but in some cases where there are changed country conditions and where there are extenuating circumstances, they're able to apply, they're eligible to apply beyond that time limit.
Talar, and the final question we received from our viewer is, what options does an individual have if he has a deportation order against him or her, but that person has not left the United States?
Again, that's a very good question, and it's a question that a lot of people have. And it's also a very case-specific question. It's very difficult to give a proper answer without having reviewed the person's file, their deportation file, their whole immigration history, basically. But as a general rule, once you have you have been in proceedings and you have a deportation order or a removal order, you are obviously able to appeal it to the Board of Immigration Appeals within a required time frame. You're also able to file for a motion to reopen or a motion to reconsider. Again, there's certain time frames, usually 30 to 90 days for these motions. In some limited circumstances, you are eligible to file a motion to reopen beyond the prescribed time limits.
And if the same person, the same individual leaves the United States, do they have any options to return to the United States?
If the individual leaves the United States after an order of removal or an order of deportation, it's very challenging for them to return to the United States. Depending on the specific case, individuals are barred from coming back to the United States from anywhere from 5 years to 20 years.
Thank you very much, Talar, for an engaging discussion today. If you have additional questions for Talar Iskanian-Hashasian, please contact her directly. Thank you again for being part of Legal Affairs.
Thank you. It's been a pleasure.
Next month, our guest will be Anna Bruno, financial advisor. We will discuss financial decisions you should be considering before the end of the year. If you do have end-of-the-year financial questions, please send them to the email address on our screen. Thank you for joining us and see you next time.